So, you've spent months, maybe even years, coming up with the perfect brand. You've got a killer name, a great logo, but what if I told you that a single letter in that name could land you in a legal battle that goes all the way to the Supreme Court? Yeah, let's get into it, because choosing a brand name is so much more than just being creative. It's about the law.
And it all comes down to this: Ambal versus Andal. Now, at first glance, they look different, right? One's got a B, the other has a D. Seems like a tiny thing. But in the world of trademarks, that tiny difference sparked a huge legal fight that actually set a critical rule for every brand out there.
And this case really makes you ask that fundamental question. It's not just about picking a name that isn't identical to someone else's. The real trick is figuring out where that line is between inspiration and, well, infringement. And trust me, that's a blurry line that can be very, very expensive to cross.
Okay, so let's set the scene. We're in South India. You've got two companies, and they're both competing to sell snuff, which is a kind of smokeless tobacco. They're in the same market, going after the same customers, with names that are, well, you're about to see just how similar they really were. And this is where it gets really interesting, because the similarities just keep piling up. It wasn't just the product. Yep, both sold snuff. But both also used an image of a goddess on their label. And here's the kicker. Ambal and Andal are both names of goddesses worshipped in that exact region. In a case like this, that context, it's everything.
So you might think this is an open and shut case, right? Well, the first authority to look at this, the trademark registrar, actually disagreed. They sided with the new guy. They ruled that Ambal and Andal were different enough. They looked at the spelling, saw the B versus the D, and basically said, you can both exist. But that was far from the end of the story.
See, the case then went up to the High Court, and this is where the logic did a complete 180. The court brought in a totally new way of looking at the problem. They stopped focusing on the spelling and started thinking about the real-world experience of an actual customer. And this quote just nails it, doesn't it? Justice Jagadeeshan's point was so powerful, he basically said, look, it doesn't matter how you say it, fast, slow, mumbled, out loud, they sound almost exactly the same. Just imagine trying to ask for one of these brands at a noisy shop counter. That's the real test.
This all hinges on a crucial legal idea: the unwary consumer. You see, the law isn't designed to protect some legal expert who's carefully comparing two labels side by side. No, it's there to protect an ordinary person, someone with what the courts call an imperfect recollection, who might only remember the general sound or the vibe of a brand. So in the end, the Supreme Court completely agreed. For Ambal and Andal, the answer to all these questions was a big yes. And by doing that, they set down this simple but really powerful test we still use today. Does it sound alike? Does it look alike? Are the products similar? If you start ticking those boxes, you've got a high chance of confusing people and a big legal problem on your hands.
Okay, so that rule seems pretty clear for similar products, like two brands of snuff. But what happens when the products are worlds apart? Let's throw a wrench in things and look at a whole new kind of conflict.
Right, this is a fun one. What if you use a famous brand name but on a product that company would never ever make? Are you in the clear? Could you, I don't know, sell Ferrari brand baked beans? Let's see what a real court case had to say. Okay, meet Caltex. On one side, you have the massive global petroleum company that everybody knows. And on the other, you had a company that wanted to start selling watches under the exact same name. Now, the products could not be more different: gasoline and timepieces. So is there really any chance of confusion here? Well, you might be surprised to hear the court said yes, absolutely there's a problem. And that's because the law gives a special, stronger kind of shield to brands that have become really famous. They just get an extra layer of protection.
This is what's called a well-known trademark. Basically, it means a brand is so famous that a huge chunk of the public instantly recognizes it. And when that happens, its legal protection gets bigger. It stretches way beyond its main business. In this case, beyond just selling petroleum.
So why does this shield even exist? Well, it boils down to three key things. First, it stops people from taking unfair advantage. You know, the watch company was clearly trying to ride the coattails of Caltex's good name. Second, it prevents harm. What if the Caltex watches were cheap and fell apart? That would unfairly damage the oil company's reputation. And third, it prevents what we call dilution. If the Caltex name starts popping up on everything from watches to toasters, the power of the original brand just gets watered down. All right, let's bring this all home.
We've looked at two really different legal battles, and they give us two clear rules that every single entrepreneur and brand builder needs to have in their back pocket.
And here it is, all boiled down. On one hand, for similar products, like our snuff brands, it's all about the likelihood of confusion test. The question is simple. Will an average person with a hazy memory get mixed up? But for totally different products, like oil and watches, that well-known mark rule kicks in. And then the question changes to, are you unfairly cashing in on a famous brand's reputation? Two different situations, two very different legal tests.
So what's the big takeaway from all of this? Your brand name doesn't just exist on paper. It's not about how you spell it, it's about how it sounds, how it looks, and the feeling it creates in a customer's mind. It's all about perception. And of course, protecting that reputation you work so hard to build. And that leaves us with one final thought. In a marketplace that is just jam-packed with similar-sounding, similar-looking brands, the real challenge is creating something that's not just unique, but legally defensible. So how are you going to make your mark stand out from the noise?